Welcome to Inside Exchange, Topics for Manufacturers, a series bringing you expert-led presentations on the issues that matter most to members. The curated topics in this series feature presentations from associate members and subject matter experts through on-demand and live webinars to help Hudson Valley manufacturers. If you have topics you'd like us to explore in future episodes, contact us at info@councilofindustry.org. Let's begin.
Hello, everyone, and welcome to this edition of Insight Exchange. Today, I'm joined by Otieno, Ombok, and Marissa Prianti from Jackson Lewis to talk about the new administration's executive orders and their impact on employers. Many of our members work closely with their team on proactive policies, compliance, and labor and employment issues. Please allow me to introduce Otieno Ombok, principal at Jackson Lewis. Otieno is a familiar face and friend of the association, and he helps employers manage employment-based immigration matters and stay compliant with changing laws. And Marissa Prianti, an associate in the firm's immigration practice group, where she works with companies to navigate complex immigration processes and keep up with evolving regulations. There's a lot to cover, so let's get started.
Thank you very much, Jania. My name is Otieno Ombok. I'm a principal with Jackson Lewis, and I'm co-chair of our immigration practice group. We are based out of White Plains in New York.
My name is Marissa Prianti. I'm an associate in the immigration practice group, also based out of White Plains, New York.
I know we're here to talk about this topic. I know that it is time sensitive. A lot of our members have been asking these questions, so I'm going to turn it over to you to just guide us through this journey.
Thank you very much, Jania, and great to see everyone again. And thank you for joining this webinar. And our objective today is to do a high-level summary of the executive orders that have been signed by President Trump, and those, targeting and focusing on not immigration generally, but those that impact employers and impact business immigration, and workforce enforcement. And soon following the inauguration of January 20th, one of the executive orders that the president signed was, of course, the one banning, birthright citizenship. And there's been a lot of media about it. We're not going to address that today. We are going to focus on those that specifically focus on business immigration. And these are, things that impact you on your day-to-day, activities. Just to point out that the information that we're going to provide, in this webinar, it should not be used as a substitute for legal advice on any particular matter. If you have any questions or if you need any guidance on any specific issue that we're going to address today, or please feel free to reach out to us. You can send us an email or you can call us. We'll provide, our information. The president signed 12, immigration-related executive orders on January 20th, and he also rescinded 5 Biden-era executive orders. And so today we are going to discuss, some of those executive orders. One, basically, enhancing visa vetting and screening of people or foreign nationals applying for visas. We are going to see how the executive orders that the president has signed is making it difficult for employers to obtain approvals of visa petitions. We are going to look at certain programs that the president has terminated or in the process of terminating, and what impact that has on you as employers from an I-9 perspective. And finally, something that's been so much in the media, and that is, worksite enforcement. You've been reading about ICE raids, you've been reading about I-9 audits and inspections. That is something that we're going to discuss. And so the net effect of these 12 executive orders that the president signed is that they're going to make it more difficult, and they're going to impact the processing and adjudication of visa petitions, not just by the U.S. Immigration Service, USCIS, but they're also going to impact issuance of visas, by U.S. embassies and consulates abroad, and particularly for employers who sponsor foreign nationals for work visas, this is something that's going to impact you, and we look into what those issues are. And secondly, there are executive orders which directed restrictions and limitations on humanitarian parole and temporary protected status. And this will adversely impact employers, particularly if you rely on low-skilled workers who are currently authorized to work in the US under those programs. And of course, if you're an employer and you may have undocumented workers, in other words, workers who do not have the legal authorization to be and to work in the US, and you may not know that they are undocumented, the president did pass an executive order impacting that, and you may, as a consequence, be impacted, as well. One of the executive orders that the president signed, it's called the Protecting the U.S. from Foreign Terrorists and Other National Security and Public Safety Threats. It calls for enhanced vetting and screening of visa applicants and those seeking immigration benefits. The objective here is to identify those who pose a national security risk to the United States. And the executive order is explicit that we should revert to the baseline for visa screening and vetting standards and procedures, that existed during the first Trump administration. And secondly, the president directed the relevant agencies, the U.S. Department of State and the U.S. Department of Homeland Security, to identify within 2 months, which is expiring next week, to identify within 2 months, countries whose citizens pose special security risks. And the objective here is that we anticipate the administration will issue a travel ban or a visa ban. This is something that we saw happen during the first Trump administration. So far we do not know which countries, will be impacted. The last visa ban targeted basically, Muslim countries. And we anticipate that, and there've of course been some rumors about it, they'll do it in a way that avoids some of the legal hurdles that the Muslim ban encountered, during the first Trump administration. And in terms of impact on employers, already we are seeing there's been a significant change that has been made by the U.S. Department of State in terms of visa interview waiver. Under what situations will the embassy or the consulate waive the in-person appearance by a foreign national who is applying for a visa? Under the last administration, as long as you had a visa which expired within 48 months, all you needed to do is to drop off your passport at the embassy, and the embassy would stamp your passport with a new visa. Under the rule that the US Department of State just instituted last month, they've reduced that timeline to 12 months. This basically means that there are going to be more people who have to show up and, in person at the embassy for the visa interview. And that's going to basically increase the backlogs. There are going to be more and more applicants referred to administrative processing, and we expect processing delays. And there's going to be disruption of business travel for employees, on temporary work visas. Now, this is going to impact you as an employer only if you have foreign nationals whom you sponsor for work visas, whether they're on H-1B or L-1 or any other visa category. If they travel abroad, they need to get new visa stamps to be able to return to the US. And this is going to have implications if you have a visa employee who is stuck outside the US, ranging from, is remote work allowed? Can you allow the employee to work remotely in their home country? If they're visiting a third country, do they have a visa allowing them to work in that third country? And from your perspective as an employer, what exposure, what type of exposure do you have subjecting yourself to local labor and employment laws and even tax consequences by virtue of that employee working in a foreign country? I mean, these are issues that we are already dealing with from, some of our clients. And of course, if you have any questions, please let us know.
I'm going to briefly go through the current situation with humanitarian parole and temporary protected status, also known as TPS. During the Biden administration, there were humanitarian parole programs in place for citizens of Cuba, Haiti, Nicaragua, and Venezuela. Essentially, under this program, these individuals, many of whom would arrive at the border, were what is known as paroled into the United States, meaning they were lawfully admitted to the United States and they became eligible to apply for work authorization. The Trump administration announced through executive order that it will be terminating these humanitarian parole programs, meaning that it will not renew any of them. So individuals who have work authorization pursuant to these programs will not be able to renew their work authorization under that category. Individuals who have work authorization based on humanitarian parole will have the C11 category marked on the front of their work authorization card. So for employers who are attempting to figure out which employees will be impacted, again, you're looking for individuals with the C11 on their work authorization cards. Nearly all of these individuals will present work authorization cards as their I-9 documents, only because they're not eligible to get Social Security cards that are unrestricted, which would be required for I-9 verification with a Social Security card. We estimate that there are approximately 550,000 individuals with this type of work authorization who may be impacted. Moving on to temporary protected status, the two major programs that have been impacted under the Trump administration are temporary protected status for Venezuela and for Haiti. Under the Biden administration, Venezuela had been designated for TPS twice, once in 2021 and once in 2023. Recently, the Trump administration announced that it will be terminating Venezuela's TPS designation. Individuals who registered under the 2021 designation, their temporary protected status will now expire September 10th, 2025, and their work authorizations expired March 10th, 2025. Individuals who registered under the 2023 designation, their status and their work authorizations will terminate on April 7th. We estimate that approximately 600,000 Venezuelans will be impacted by this termination. There are currently 3 lawsuits pending in federal district courts around the country that seek to enjoin the termination of Venezuelan TPS. Thus far, there have not been rulings in those cases. However, we are keeping employers updated through our blogs, through our Jackson Lewis blogs, which we encourage you to follow. With regard to Haiti, DHS recently announced that the TPS designation will terminate August 3rd, 2025, and everyone with work authorizations pursuant to Haiti temporary protected status, those work authorizations will also expire August 3rd, 2025. Obviously, the impact on employers will be significant in terms of both reduction in number of workers and labor shortages. If there is any good news, it is that many of these individuals may have applied for asylum subsequent to receiving TPS, and they may have work authorizations based on these asylum applications. As an employer, you cannot specifically ask individuals if they have work authorization based on asylum. However, we're always available to answer questions about how best to approach employees whose work authorizations will be expiring because of these rescissions of temporary protected status, and how best to re-verify them.
Yeah, and one question that employers have been asking: how can they identify employees whose work authorization will expire either under either program?
Yes, thank you, Otieno. They can identify them by looking for the A12 or the C19 designation on the face of the employment authorization cards for individuals who have temporary protected status. As I mentioned, it is the C11 designation for humanitarian parole and the A12 or C19 for temporary protected status.
Okay, thank you. This is our last, slide, basically addressing business immigration.
Yes, we're going to address the Trump administration's use of increased interior enforcement in a couple of contexts. The first is expanded use of expedited removal orders. An expedited removal order means that an individual can be removed from the United States without first having the opportunity to go before an immigration judge. These expedited orders will be applied to individuals who entered without inspection within the last 2 years. Traditionally, they were only used for individuals who had entered within the last 2 weeks and who were found within 100 miles of the border. They are also going to be leveraging federal, state, and local law enforcement to essentially augment the work of immigration enforcement, specifically ICE, Immigration and Customs Enforcement. There is something known as the 287G program that essentially allows ICE to deputize local law enforcement to carry out immigration enforcement duties. One of the Trump executive orders also created Homeland Security task forces that essentially allow for easier and increased cooperation between state law enforcement agencies and ICE. And then finally, the Trump administration is targeting sanctuary jurisdictions, often known as sanctuary cities, looking at, again, increased enforcement action. We've already seen this, for example, in New York and Chicago. We've seen stepped up enforcement actions, ICE raids that have received a lot of coverage, or arrests of individuals who are believed to have criminal backgrounds. And again, a lot of these enforcement actions will come in the form of ICE raids and I-9 audits.
Thank you. And, during the last Trump administration, the immigration officials, through policy, memoranda, and guidelines, if you could move to the next slide. Yes, through policy, memoranda and guidelines, and without changing immigration law, implemented certain policy changes which made the immigration system too restrictive. Those changes basically increased the rate of, requests for evidence and, denials of visa petitions. The rate rose to unprecedented levels. And, they also introduced unnecessary, I may say, in-person USCIS interviews and biometric appointments, and they made it difficult for applicants to gain, U.S. permanent residency, tightening the public charge requirements. Now, and all that was done under, the Buy American, Hire American executive order that President Trump signed in 2017 when he came in the first time. Now, when President Biden came in, he, of course, rescinded the Baja executive order, and he also passed several, immigration executive orders, one of which was, this 14012, and that was basically aimed at restoring faith in our legal immigration system. And this is really the executive order which significantly helped to streamline and facilitate the processing and adjudication of visa petitions, and visa applications. And of course, President Trump, when he came in, the second time, he rescinded this Biden executive order. And so what we anticipate, and we already started seeing it happening, is that things will revert to the way they were during the last Trump administration. Now, what does this mean? And what this means only impacts employers who sponsor foreign nationals for visas. And so we anticipate seeing increased scrutiny of visa petitions and applications by the Department of Homeland Security and by the Department of State. We anticipate seeing more requests for evidence where immigration will ask questions, seek clarifications on different aspects of a case that's filed for approval, depending on what type of visa it is. And we anticipate to see more denials. One rule that President, Biden reinstated, was what is called deference to prior adjudications, meaning if you're sponsoring an H-1B employee if you're sponsoring a foreign national for an H-1B visa and you get the visa approved for 3 years, when you file for an extension and when immigration is adjudicating the extension petition, they will respect their initial approval. They'll say that you're filing for an extension, we approved this 3 years ago, so we'll approve it again. So what we anticipate to see with the new administration is end of deference. They will not respect their prior adjudications or decisions. And this is going to mean, increased costs for employers because you have to incur more legal fees and legal costs addressing those requests for evidence, addressing denials, refiling cases and appealing denials. And of course, the processing times are going to increase as well. We also anticipate seeing certain changes. It's going to be more difficult to obtain green cards or U.S. permanent residency. We anticipate the administration is going to make it more difficult, for people to obtain, adjustment of status through or an immigrant visa, and this is something that they're going to accomplish through rulemaking. They'll need to publish a rule, in the Federal Register. And there are also certain programs that we anticipate will be targeted. If you have, F1 students who are employed on, what is called, STEM or STEM OPT, those are going to be impacted. If you have, employees who have H4 dependent visa with employment authorization, we anticipate at some point the government is going to start looking, at those programs. And so we wanted to highlight this issue, particularly if you're an employer who sponsors, foreign nationals for visas. If you have any questions on what exactly this means for your visa employee population, please feel free to reach out to us. Thank you.
Otieno, just before we move on, do we also anticipate any issues with the Department of Labor when it comes to labor certifications?
That is correct. The Department of Labor is involved in the visa process to the extent that they have to certify that there's a shortage of US workers who can do the job. The employer has to do a labor market test and basically submit an application to the DOL after it has, advertised the position in the media and can demonstrate and can attest that there is no suitable workers who are US citizens or US permanent, residents. And so we anticipate that this is something that, the government is going to look at already. Just even aside from the Department of Labor, we have the US Department of Justice that's looking into anti-discriminatory practices by employers. And the EEOC, acting chair just announced 2 weeks ago that they are going to basically investigate employers who they say discriminate against US citizens and permanent residents, and that they'll be investigating not just staffing agencies who hire foreign nationals, mostly from India and China, but also US employers who likely have large sponsorship programs and favor foreign nationals or instead of US workers.
Thank you.
Yeah.
I'm going to go through the function of ICE, or Immigration and Customs Enforcement. It is broken down into a couple of component parts. Two of the main parts are Homeland Security Investigations, also known as HSI, and Enforcement and Removal Operations, also known as ERO. Essentially, HSI is composed of agents who are investigating a number of criminal activities. They're looking for specifically for a fraudulent sponsorship of immigrant and non-immigrant visas, I-9 fraud, human smuggling and trafficking, etc. I will say that, and we're going to discuss it a little bit later, we are seeing an increase in I-9 audits of employers, even when there is no apparent reason for ICE to believe that the employer is engaged in any type of I-9 fraud. These appear to be just random audits in many cases. With regard to enforcement and removal operations, as the name implies, this is the branch of ICE that is in charge of actually deporting individuals. They are the individuals who will arrest and detain undocumented individuals. All right. So, moving along, what happens if ICE shows up? This is, one of the main questions that we're getting from employers, and obviously there has been a lot of recent media coverage. ICE can be there for a couple of reasons. ICE may be there to conduct what is known as a raid, and again, we'll come to this shortly. They may be there looking for undocumented individuals who they're seeking to arrest, or they may be looking for specific documents, for example, I-9s or other personnel-related files, or information. For example, they may want to know if a specific individual is employed by an organization or an entity, or if they are physically on the premises. ICE you may or may not have noticed that ICE is going to show up. Frequently, when ICE obtains a judicial search warrant to search a premises, they will not provide any advance notice that they're coming. They want the element of surprise because they don't want anyone who may be undocumented to flee the premises. Anyone, including ICE agents, can enter public areas of a business without permission. However, ICE must have a valid judicial search warrant to search non-public areas of the premises. Public area is basically any area that someone can walk into from the street. Any area where you would need a ID badge to enter, or a visitor would have to be escorted, is not a public area. Again, other examples of public areas include parking lots, waiting areas, reception areas, etc. And again, no one can enter a private area without a judicial warrant, and we will get into how to tell the difference between a judicial warrant and other type of document shortly. All right. A raid versus an audit. As I mentioned, a raid is essentially a situation in which ICE is coming in with no notice, presumably with a search warrant, and they are there to either search for information or search for undocumented individuals. Sometimes they're there for both reasons. It's usually the culmination of a criminal investigation of either the company, owners or managers, or undocumented workers. Again, before ICE is going to be able to obtain a judicial search warrant, they're going to have to convince a federal judge that there is a probable cause to believe that there is illegal activity going on. So there will need to have been a substantial criminal investigation done first. And again, this can be, triggered by tips from former employees, from customers, members of the public, or because ICE has reason to believe that the business is employing undocumented individuals. Again, these are often known as judicial warrant enforcement actions. An audit is something quite different. It's a civil inspection. Essentially, ICE will serve a business with something known as a notice of inspection, where the business will have 3 business days to produce the I-9s requested by ICE. Usually, ICE wants to review I-9s of all active employees, as well as those terminated either within the past year or within the past 3 years. Once ICE has concluded its review of I-9 forms, it can result in a criminal investigation, but more commonly, you're going to see a warning, or sometimes employers will be fined. what can we expect and what are we already seeing? We are already seeing these worksite and visits and enforcement actions. Some of them have, again, been very widely covered in the media. Others, like serving notices of inspections, are, obviously not something that's going to incur any media coverage. Worksite enforcement actions can be divided into 5 distinct categories. First, as I already mentioned, are the types that involve judicial search warrants. This is the only time ICE is allowed to enter non-public areas of the premises without the consent of the employer or the employer's staff. Again, it's usually the culmination of a criminal investigation, and a judicial search warrant is always going to be issued by a federal judge sitting in the U.S. District Court that covers the premises being searched. ICE has also been known to show up with administrative warrants that are issued by the Department of Homeland Security. They commonly have a form number on them called Form I-200, but there can be other form numbers. The key things to look out for with an administrative warrant is that it will usually say something like ICE or DHS on it. We'll also often have the ICE or DHS logo, and it is going to be signed by an immigration judge or an immigration officer, sometimes known as, sometimes it'll say USCIS officer. These administrative warrants issued by the Department of Homeland Security or ICE, they do not carry the force of law. Employers are not required to allow ICE to search if they present one of these warrants. There is a small carve out if ICE shows up with an arrest warrant for a specific individual. In that case, employers do have to allow ICE access only to that specific individual. Again, they are not authorized to search the premises. Similarly, with administrative subpoenas, they're often on documents called Forms I-138. Employers are not required to provide information in response to an administrative subpoena. Again, it does not have the force of law. Employers, as I mentioned, may be presented with a notice of inspection. This is in the case of an I-9 audit. These instances are very different. ICE is usually not there in an intimidating manner. It'll often just be 1 or 2 agents who will simply serve the notice of inspection. Employees should check the notice to make sure that it is for the correct business and the correct business address. But beyond that, they should accept the notice of inspection and get it to Immigration Counsel as soon as possible. Because you do want to be represented by counsel if you are being inspected. And finally, FDNS investigations. These are fraud detection and national security investigations. We're not going to get too far into these. They are, they can be initiated in conjunction with state law enforcement. Again, looking for, I-9 fraud and similar issues.
Yes, and I-9 audits, we are more accustomed to this. This is when, ICE issues a notice of inspection. Basically, as employers, you're required to maintain, I-9 forms on file for all current employees. And for termed employees, you maintain them either for 3 years from date of hire or 1 year from date of termination, whichever is longer. And we always advise that, you should keep I-9s on file for all active or current employees, and also for employees terminated within 3 years, so that if you receive the I-9 audit notice of inspection, you will be ready to present them, when required. And they are only obligated to provide a 3-day notice. And, the question is, will you be ready once you receive that 3-day notice? What's the state of your I-9s, and will you be ready, to present them? And so, as Marissa has indicated, the notice is usually served, on the employer by 1 or 2 agents, from ICE. They will visit the company premises in person and, provide, serve the notice, and will require a signature. And don't forget, you have 3 days to present the I-9. Sometimes you may have an agent that says that I just need the I-9s right now, today. Please do not waive your right to the 3-day notice. Don't sign on the dotted line. They know you have 3 days, and just accept the service and contact your immigration counsel and work with them to ensure that you present the I-9s within a prescribed time. If you engage us to assist with this exercise, the first thing that we would do is to reach out to the ICE agent and ask for an extension of time. In our experience, and even under the new administration, because we are now handling many of these ICE audits throughout the country, they're very cooperative, and we've been able to receive extensions of time to present the I-9s, either 1 week, or 2 weeks if it's reasonable. Again, it depends, on the size, of the employer. And the I-9 audit notice basically asks the employer to surrender their I-9 forms for inspection by ICE, by the government. And I-9 forms could also include, I-9 documentation. And in the previous slide, we actually have a sample of what an I-9 inspection notice is to the right. So there may be variations here and there, but basically it will reference the legal authority that gives the agency the power to request you to surrender the I-9s. And in addition to serving you with a notice of inspection, or the ICE may also request other information other than I-9 forms and supporting documents. And this they do through issuing an administrative subpoena that asks you to provide some other corporate documentation and information. For instance, they could ask you for a list of all your employees, either a list of all your current employees or a list of all employees hired within a certain time frame. And they could indicate that the list should include the name of the employee, the date of birth, the social security number, the hire date, or if someone is termed within 3 years, they may also ask for you to provide the termination date. I mean, the subpoena could also ask of, a list of all payroll, like which employees are currently on your payroll, and provide wage information. And finally, they could also ask for information on the corporate structure of the company, your articles of incorporation, your annual report or financial statements, or your business licenses. Now, this is the difference. If it's an I-9 inspection notice, that 3-day timeline applies. You have to present the I-9s to ICE within 3 days, unless you are, granted an extension of time. But with regard to the administrative subpoena, that's something that there is more leeway. You could present them later. Just let the officer know that, the additional documents, corporate documents, and information they've asked for is not available. And usually they can allow you more time to present those. Now, so the first step in an I-9 audit investigation is ICE serves you with a notice of inspection. You have 3 days to surrender the I-9s, or a week or 2 weeks if you get an extension of time. During that timeline, of course, I would suggest you work with your immigration counsel to make sure that you have I-9s on file for all employees. One of the things we've been seeing lately, previously, if an employer received an I-9 audit notice, they could, within that time frame, make corrections to the I-9 forms, or ask employees with no I-9 on file complete new I-9. So if you have an employee whose work authorization document already expired, contact that employee and ask for new work authorization documents. But what we've been seeing this year in most of the I-9 inspection notices our clients are receiving is that they're making it clear that no changes, no corrections should be made on the I-9s once the notice of inspection is served. And so this is why it's critical that as employer, you conduct periodic audits, periodic internal review of your I-9s to ensure and verify that you are in compliance. So the notice is served as step one. You work with counsel to make sure you have all the I-9s and surrender them to ICE, whether in person, they may collect them, or they may allow you or ask you to transmit the I-9 forms electronically, as an email attachment or through a secure email system. The second step on the next slide is the Department of Homeland Security may notify you that it intends to arrest some employees, and they may request your cooperation. And usually this will happen if DHS finds that there are employees who presented fraudulent documents, or there's ID theft, that have been lodged with, government agencies. If that happens, then the government will give you notice that they would like to come and arrest certain employees. So of course, and when they come, I think, Marissa, they have to serve a warrant to get access to the premises.
So no, if they show up with a warrant, an arrest warrant for specific employees, then they don't need a judicial search warrant to enter and arrest those specific employees. They will typically say to the employer, "We're here to arrest John Smith," for example, and they will ask for the employer's cooperation in either bringing them to John Smith or escorting John Smith to them. And employers are advised to cooperate in these circumstances. You never want to try to hide an employee or assist anyone in fleeing. The penalties for that can be heavy fines and up to 5 years in prison.
Yes, and so I think as we conclude the I-9 audit notice piece, just to make sure that, the state of your I-9s is current, they are updated, any re-verifications that need to be done are done. And, if you don't have any I-9 on file for any employees, make sure that you do, bearing in mind that, the I-9 law and regulations have been with us since 1986. So if you have been in business for longer than that, if you are established before 1986, you may have employees who we say are grandfathered. If you've been in business since 1980, for instance, employees hired between 1980 and November 6, 1986, those are grandfathered employees, which means you do not need to have an I-9 on file for them. But anyone hired after that date, November 7, 1986, you should have an I-9 on file and be ready to present them if you receive an ICE audit. And in the current environment of increased worksite enforcement, we should proceed on the assumption that any employer, regardless of the industry, although we know there are certain industries which are targeted, but any employer, regardless of industry, can be a target of an I-9 inspection. And so you should have your I-9s ready.
Definitely. And just to piggyback off of what Otieno said, I'm handling several I-9 investigations, and they have targeted employers ranging from nonprofits to employers in the hospitality industry, which is more traditionally targeted. So as Otieno said, we're seeing it across a range of industries. Just before I move on, Otieno, how can we help employers if they want to conduct an internal audit to ensure they're ready for an I-9 investigation?
Yes. Yes. So it's, as we say, it's advisable to periodically review your I-9s to make sure that you're in compliance, to correct any, I-9s which require correction and re-verification. And depending on the size of the employer, depending on the setup and structure of the, HR function, while, it's okay for whoever is in charge of the I-9 function to periodically, review their own work, their own I-9s. Our recommendation is to maybe once in a while, maybe in a few years, engage immigration counsel to assist with the audit review And the advantage of that is that, if you were to engage us, we would be doing it under privilege, attorney-client privilege. And when we do it, it's very intensive, it's very exhaustive in terms of, we would give you a report listing all the errors, the mistakes that we've identified, the common errors and common mistakes, the discrepancies, and we'd also, provide a memo highlighting how the errors and the mistakes are supposed to be corrected, whether the correction should be done by the employee or by the HR person. Is the error in section 1 of the form, or is it in section 2 of the form? And more importantly, we would provide training, to the folks involved in HR, in the I-9 function, so that they know, the do's and don'ts in the I-9 compliance area. So I would strongly recommend that, if this is something that you've not done, over the last few years, you seriously think about it, because, based on your industry, which is manufacturing, that is an industry that could potentially be targeted, by the current administration. We know it's been targeted in the past, and so you always want to be ready for that I-9 inspection, because the consequences, could be far-reaching. Once ICE audits, and they find errors and mistakes, there are technical violations which will attract fines, but there are also substantive violations if they find that you have, unauthorized workers who are not, authorized to work in the US, the fines are going to add up. And we have, there are employers in the US who've been bankrupted because of I-9 investigations. And so it's something that we need to take seriously. And as Jackson Lewis, we are here to help and to assist.
Absolutely. So I'm just going to go through a couple of other potential steps in the I-9 audit process. The next step can be, and this does not always happen, but it can happen, DHS or ICE can serve a notice of suspect documents. And this is simply a list of individuals where ICE has determined that the document doesn't relate to the employee or is otherwise not valid for employment. For example, somebody presented a green card under the name of John Smith, and it turns out that they are in fact John Doe. ICE has determined that a green card is fake. It's not a legitimate green card. The employer will be advised of possible criminal and civil penalties if they continue to employ unauthorized workers. It is important to note that this list can contain employees who passed E-Verify. There are, unfortunately, quite a few instances where there's either been ID theft or an employee has used somebody else's ID who is lawfully in the United States and authorized to work. So it is important that employers not become overly complacent simply because an employee has been deemed authorized to work through E-Verify. Employers are given 10 days to follow up with employees on these lists. Failure to do so and to resolve the situation can result in a knowingly hire violation, which can result in very significant fines for the employer. As Otieno said, substantive I-9 violations, the fines can really add up, but fines for knowingly hiring undocumented individuals are much higher. Extensions beyond 10 days are rare. You would need to make the business case for why you could not resolve the situation within 10 days. Again, ICE is very hesitant to permit employers to continue employing individuals who they believe to be undocumented. In these situations, most employees will have to be terminated within a short time, which can cause operational issues. However, it is very important that you not automatically terminate these employees. Sometimes there's a legitimate explanation, or sometimes ICE does get it wrong and the employee is in fact authorized to work. And you don't want to wind up on the other side of the coin with the employee lodging a discrimination claim against the business. So again, if you are under investigation, even if it just appears to be a routine I-9 audit, as Otieno said, it's very important to engage counsel. The next step is that ICE or DHS will serve a notice of discrepancies. And this is, again, a list of individuals where they cannot determine the employee's eligibility to work in the US. And again, as I said, employers need to be very careful. Not everybody who HSI or ICE cannot verify as to be employment authorized is in fact unauthorized. We see instances all the time where somebody, for whatever reason, is not verified as work authorized through E-Verify, but they have clearly presented valid I-9 documentation, and then the employer has to go ahead and close the case and indicate to E-Verify that they're going to continue employing the individual because they reasonably believe them to be work authorized. When it comes to approaching employees who you believe may not be work authorized or who have wound up on a discrepancy list, it's very important to work with counsel on how to approach them. The key point is that employers cannot tell employees what I-9 documents they need to present. Many employers wanting to quickly resolve a situation will be tempted to tell an employee provide, whether it be a green card or a work authorization document for temporary work authorization, just provide that so we can get this over with. You never want to do that. It can result in a discrimination claim. In reality, many employees who wind up on a discrepancy list will quit as a practical matter, but again, not all. Some will say, no, I am in fact work authorized, and will hopefully present valid work authorization documents. And then the final step is that DHS or ICE is going to review the original I-9s and return them to the employer. Again, it's not always original paper I-9 forms. Obviously, many employers today use electronic forms through major platforms such as Workday, Equifax, etc. If there are errors on the I-9s, DHS will return them with a notice of technical or procedural failures. As Otieno mentioned, these corrections or these failures must be remediated within 10 business days. This is another area where you want to make sure that you're working closely with counsel to ensure that the corrections are done properly. It is not as straightforward as it would seem to make a correction to an I-9 form, and obviously you don't want to give up the opportunity to make the correction properly, which will in all likelihood result in fines. Sometimes ICE or DHS makes suggestions to changes in employer policy, such as changes in onboarding. Often they'll want new hires to watch certain training videos or HR to undergo additional training. If the employer does not participate in E-Verify, ICE will often recommend that they participate. And then finally, ICE or DHS will decide the outcome of the audit, which can be a notice of intent to fine, which, as the name implies, means that they intend to fine the employer, and they will tell the employer what the fine per I-9 will be. Sometimes an employer will get a warning notice, particularly if it's a first offense and they all appear to be errors that were, made in good faith. For example, there was no knowing hire of undocumented individuals. And then sometimes employers, particularly those who regularly do internal audits, will receive a letter of compliance, meaning that they have been deemed compliant following the conclusion of the I-9 investigation. Switching gears a little bit, ICE raids. We alluded to them earlier. They've received a tremendous amount of media coverage recently. They're often known as judicial warrant enforcement actions. What are they? How can employers prepare? What should they do? So to start with, what is an ICE raid? It is a full-scale law enforcement operation. It is sometimes coordinated with local law enforcement. Again, that will not be true in every jurisdiction. For example, the NYPD, as a matter of policy, does not cooperate with ICE, although that may change given the current political situation. When there is an ICE raid, as I said before, ICE will need to have obtained a valid judicial warrant. ICE will have to obtain a judicial warrant from a district court judge sitting in the U.S. Federal District Court that covers the site that ICE is searching. We are almost certain that the Trump administration will try to push the limits on the type of warrant that ICE may present. ICE may try to enter without a warrant, or they may, as we alluded to earlier, show up with something called an administrative warrant and try to convince an employer's staff that it is a valid warrant and that they have to be granted access. Once ICE is on the premises, there's the potential for them to seize company records, arrest employees who they believe to be undocumented, etc. Again, this is why it is really, really key, and we'll get to this in a minute, that your employees be properly trained in how to tell the difference between a valid judicial warrant and other documents. Just to go through some predicted worksite strategies, as Otieno mentioned, they're going to be targeting likely specific types of industries. Hospitality seems to be one that's at risk. We've seen some of these raids in food production facilities. Other manufacturing plants, as Otieno said, are often targets of these types of raids as well. This isn't to fearmonger. This is to ensure that employers are prepared, and we'll get to this in a minute, that staff is properly trained on what to do and what not to do in the event of a raid. Again, during these raids, undocumented workers can be arrested, and possibly company management, depending upon reason for the raid to begin with. And again, many of these raids, they're intended to attract media coverage. They're trying to get undocumented individuals to self-deport or leave the country of their own volition, and to discourage illegal immigration.
And, the next, who is a target? Are you a target? Should you be concerned? And we say that, if you have unlawful workers visible at a work site, and how can unlawful workers be visible at a work site? I mean, if the nature of your business is such that, your people in the morning, at the gate, waiting to be called in, to join in a manufacturing line or a construction site, that is something that's going to make you a potential target for an ICE raid. If you have, contractors from a staffing company, at your site, that is something that's really of special interest, to this administration, and not just to the Department of Homeland Security, where ICE belongs, but also for the Department of Justice, and as we've seen from the EEOC as well, they'll be looking at. Now, you may have, informants, or tips to the government agencies, disgruntled former employees or employees picked up by ICE, or even by local law enforcement if they are cooperating with ICE under the 287G agreements that Marissa has talked about. Those are all, avenues for the government to obtain information, about you as an employer and make you a target for an ICE raid. And of course, sanctuary jurisdictions, we've talked about that, certain cities and localities, which are not cooperating with the Department of Homeland Security, they can be targeted. We saw early on the first few weeks of the Trump administration. It is something that's still continuing. Chicago, for instance, was targeted. We saw a few raids, in New York City and in Colorado as well. So that makes employers in those jurisdictions a target for an ICE raid.
How can employers be prepared? What steps can they take now? And one of the first steps that employers want to take is to designate an ICE liaison. And this is essentially the individual who is going to interact with ICE agents and ensure that the employer's proper protocols that they put in place in the event of an ICE raid are followed. Some of the things that an ICE liaison might do are ensure that outside immigration counsel are contacted, that they obtain a copy of the warrant or notice, that appropriate managers or supervisors are notified, and reminding employees that they have the right not to speak to ICE if they don't want to. Now, a major caveat here is that frequently when ICE shows up, particularly if they know they have a valid judicial search warrant, they often will not wait for, counsel to be contacted or a supervisor to show up. They're just going to go in and start searching, particularly if they're looking for unauthorized workers, because they obviously don't want people to start fleeing the premises. So as I'm going to discuss, it is very important that your frontline staff, whether that's security or reception, is prepared to tell the difference between a valid and an invalid warrant and is prepared to take basic steps. We understand that you don't want to put too much pressure on them, but again, it's really key that they be prepared to take basic steps. So what are those steps? The first is that they always have to stay calm and assess the situation. Some individuals have the tendency to become extremely frightened if they see ICE. Others have a tendency to become aggressive. Neither is the right approach. You want to be calm but assertive. Obviously, ascertain why ICE is there. Again, as we mentioned, ICE could be there to serve a notice of inspection, and you do not want to initiate a whole series of protocols if they're there merely to serve an I-9 notice of inspection. If ICE indicates that they want to search the premises or that they're demanding information, at that point, staff need to request, a warrant, specifically a valid judicial search warrant. If and only if staff has determined that there's a valid judicial search warrant, should ICE officers be allowed in. If there's a valid judicial search warrant, staff should never attempt to prevent ICE from entering. However, nor should they consent. They should simply not obstruct ICE from entering and conducting the search. It is very unlikely, and I'm asked frequently, what happens if ICE shows up, they don't have a warrant, but they're breaking the door down anyway, and they're being aggressive and intimidating. This is less likely to happen, not to say it couldn't happen, particularly in the current political climate, but generally speaking, ICE knows that if they don't have a valid judicial warrant and they enter by force, the search could be challenged as unconstitutional. But if this were to happen, again, staff should never physically resist. They should obviously contact the ICE liaison immediately, as well as outside immigration counsel. Now, moving to what staff should be looking for. This is what a judicial search warrant will look like. It is always going to have a district court heading at the top. This one happens to be from the District of Minnesota. Here it would be, depending upon where your business is located, potentially from the Southern U.S. District Court, from the Southern District of New York, or for the Eastern District. Again, you're always looking for this caption, this heading, and then there will be a case caption. Staff should very quickly look to see, is this in fact signed by a judge? It can be a district court judge or a magistrate judge presiding in that court. A couple of other things that staff should be looking for when they're looking at a judicial search warrant. They want to make sure that it lists the address of the premises being searched. If you have multiple locations and ICE has a warrant for a different location, they cannot search the wrong location using a warrant. Is the warrant being executed within the proper time frame? Most federal judicial search warrants have to be executed within 14 days, but the warrant will give the time frame in which it must be executed. And again, what is the scope of the warrant? Most of these warrants are pretty broad in scope, but for example, if the warrant allows ICE to search for I-9 documents, ICE should not be running around trying to arrest people. And again, while staff should never obstruct ICE, they can always say that they object to the search because they believe it's outside the scope of the warrant. This makes it a little easier for lawyers to challenge the search as unconstitutional later if we find out there are grounds to do. These are just attachments that you might see to a search warrant. Again, the location of the property to be searched. For example, it may say within the entire premises and vehicles. If there's a garage on site, if there's one or more building, it will specify the buildings. It may even specify, the boundaries. Description of items to be searched for. Again, this warrant gives authority to search for alien, unauthorized individuals, and false documents, essentially. All right, again, on-site action. Staff should never interfere with a search. As I mentioned before, they should never hide or attempt to help anybody flee. There are very significant fines and penalties for this. ICE are absolutely free to make a record of when agents arrive and ask for their names. They can accompany them around the facility. They can take notes and regarding who they talk to and what they're taking. They can also take photos. Staff should always ask to make copies of any documents seized. ICE may or may not allow this. They should also make sure to ask for a list of all items that have been seized. ICE is supposed to provide this. In terms of making statements to ICE, we recommend that staff be advised that they should not make any statements on behalf of the company to ICE. They can simply say, I'm not authorized to make any statements on behalf of the company. You should not, however, direct individual staff members not to speak to ICE about their personal immigration situations. By personal immigration situations, we mean, are they authorized to work? Do they have lawful immigration status? That has to be up to the individual employee. You do not, as the employer, want to be accused of obstructing ICE from, trying to identify and remove unauthorized individuals. We talked about this a little bit earlier, but administrative warrants, they are typically issued by DHS. They can either be search warrants presented, as search warrants to search the entire premises, or they can be arrest warrants. Again, they are valid when it comes to the arrest of specific individuals, but they're not valid for searching premises or entering private property for the purpose of searching. This actually is labeled as a judicial search warrant. This is actually not a judicial search warrant. This is an administrative warrant. One thing to note about these warrants is you will see it's issued by the U.S. Department of Homeland Security, and it will often say warrant for arrest of alien. Again, if ICE shows up and says this is a valid judicial search warrant, we're here to search the premises. Absolutely not. It's not a valid judicial search warrant. They should not be granted access. If, however, ICE shows up and says we're here to arrest John Smith, and John Smith's name is listed here, and they checked off the reason for his arrest, and it's signed by an immigration judge, you do have to provide ICE with access to John Smith.
Yes, and as we conclude, we want to address two important questions. Number one, what do you need to do to prepare? We are saying that please do not wait for an I-9 audit. Please do not wait to be raided by ICE. What can you do now to prepare? And, number one, if you receive no match letters from Social Security Administration or from the IRS, please address them. No match letter will basically say that, you did, payroll, wage withholdings for this particular employee, but we cannot match their records their name in our records or in our systems. Please address those no match letters whenever you receive them. And number two, I'm going back to periodic I-9 reviews, timely verifying expiring work authorization documents, particularly now that we know that the administration is targeting those two programs that we talked about earlier, humanitarian parole and temporary protected status. Nationals of Haiti, Venezuela, and the few other countries impacted by humanitarian parole. So have a tickler system in place whereby you provide employees with advance notice that their documents are going to expire so that they can provide, new documentation. And we cannot emphasize enough the significance of having Immigration Council assist with internal review, of not just I-9s, but also your onboarding practices. When you onboard new employees, what are your protocols? What are your procedures? Are you doing everything right? And this extends to beyond onboarding, during your recruitment and hiring. What are the questions that you are asking, job candidates? Are you asking permissible questions, or are you asking questions which may make you a target of an investigation by one of the federal, agencies? And it's very important that, you of course, this is training, and it's good that you're participating in this training, but have protocols in place. Right now, if you do not have, an ICE preparedness plan in place, you can call it law enforcement policy, you can call it ICE readiness plan, you can call it, rapid response plan or policy. If you do not have one, a policy in place by now, we suggest, you seriously think about this and consider having one in place.
Thank you, Otieno. And just to add to that, obviously I went through basic steps that employers can take during a raid and that staff can take. However, given how important it is to ensure that ICE is not, staff don't inadvertently grant ICE entry when they don't have a valid judicial search warrant, we are working with a lot of our clients to craft customized policies and procedures specific to their facilities and their employee population so that they will be ready in the event of an ICE raid. We encourage you to consider that as well. Again, once ICE has been voluntarily allowed entry and they've started, potentially arresting individuals or seizing documents, while you can later go back and challenge the search in court on constitutional grounds. Once that process is started, it is very difficult to stop. Individuals who've been arrested may already be in removal proceedings or already deported, and that I-9 investigation or whatever the investigation that was triggered through the seizure of documents may already be underway. So again, very, very important to make sure that your staff, including your frontline staff, is prepared.
Yes, and finally, know your contractors. As we've said, the obligation to maintain and complete an I-9 only extends to employees. It does not cover contractors or, people, workers that you hire through a service, a vendor or a staffing agency. And so sometimes ICE may raid your premises targeting not your employees, but contractors working at your site. And so we suggest that, you review your contracts with contractors to make sure that, they are obligated to verify the employment eligibility, of all the workers that they send, to your site. Now, if you are hiring and a new hire discloses that they are not work authorized, you are not allowed to retain them as a 1099 worker, a 1099 employee. You're not allowed to retain them as a contract employee just to evade the obligation to complete an I-9. That is something that's going to attract civil fines and even, criminal penalties. And so in the last slide of this presentation, we've outlined the steps that as employer you can take to make sure that you do not become liable for the activities of your staffing companies or contractors who place workers, at your site. One, reviewing contracts with service providers and ensuring that they have immigration-related provisions. Something to the effect of, please, that the contracting company will ensure that all workers assigned to our site go through the I-9 process. And you may even have indemnification clauses. If ICE raids and fines or workers who are not authorized and issues a fine, a civil fine against the company, the contract may provide that, you will look up to the staffing agency, to indemnify you for any costs or any damages, assessed by ICE and other government, agencies. But we have to be careful here. You don't need to have an I-9 on file for contractors. And so you don't want to be too involved in their I-9 processes and procedures. Number one, it's not recommended, for instance, that you review their I-9s. You cannot ask a contracting company that before you place any worker at our site, please transmit the I-9 forms for these workers for us to review. No, that is not permitted. Or that will expose you to potential liability, and you may be deemed a co-employer for I-9 liability purposes, and you do not want to go there. And so we suggest you evaluate your overall relationships with contractors and put in place, provisions and mechanisms that's going to protect you in the event of whether it's an I-9 audit, but more likely if it's an ICE raid. Well, with those, if you have, any questions, if you need any assistance, whether it's on visa sponsorship, whether it's on conducting internal review of I-9s, if you need to have an I-9 compliance policy in place, if you need an ICE raid or rapid response plan in place, please feel free to reach out to us. Thank you very much.
Thank you.
Wow, guys, thank you so much. That is a lot. That is a lot. I really appreciate you taking the time to go through all that. I did jot down a couple of my questions. I think you answered them, but just for fear of being redundant, you had mentioned train, right? And I know you had mentioned obviously the HR staff and the front receptionist staff, but does the training need to go beyond that? Are the regular employees needing to know about this, or is this just if they get to the point where they're an employee, then
when it comes to, I can answer that. When it comes to ICE, yes, your regular employees absolutely should know what to do in the event of an ICE raid. Everyone from your security guard to your receptionist, because these are the individuals who are going to encounter ICE agents first. And again, we don't want ICE searching the premises while they're trying to find supervisors and higher level managers. So with regard to ICE raids, absolutely. Otieno, do you want to answer with regard to other?
I agree. And of course, when ICE, comes knocking, within 5-10 minutes, the situation can really change and can be escalated. No one, it's law enforcement. And so the liaison person is very important. Could be the head of security, could be the plant manager or the operations manager who is on site, readily available on short notice, because, if ICE shows up, the receptionist cannot say that the only person authorized to engage with you is out. Wait 30 minutes, wait an hour, or come back tomorrow. That's not going to happen. And so there should be a hierarchy, several people listed as the primary, liaison with ICE. But the role of the liaison person really immediately, within a few minutes of ICE showing up, we would suggest they notify the departmental managers, the different units, who can, let their employees know in their units that there's ICE on premises. The idea is to avoid, of course, escalating the situation and making sure that everyone is calm. And we want to avoid a situation where, once that notification is sent, there's, a rush to the entrance, to the gate, of the company, people rushing to leave the premises. That should not happen. So the notification is just meant to make sure that everyone knows what's going on and act responsibly. If at that stage that policy in place and everyone who needs to know is aware of it, then it's something that's going to be better managed and easily managed than if there's no policy in place.
Okay, that makes sense. So, I mean, I know a lot of companies have all kinds of emergency contingency plans, right? What happens if your database goes down? What happens if there's a pandemic? And also, what happens if the authorities show up asking or with this information? So having some sort of policy in place, that makes sense.
Sure.
You had mentioned, and this might be obvious to those people listening, but you had mentioned that sometimes the E-Verify would go through because it's some sort of a false identification. How should the employer know that? I mean, is there a red flag that they should be looking at? Is it just once it gets bounced back at a future date or once it gets identified? I'm just curious if I'm an employer and I'm taking their ID and I'm going through my process to e-verify and it seems okay, what could happen next?
A couple of things. So if the question is how can employers, try to look out for this to begin with before it happens?
Yeah.
One thing is to, carefully take a look at photo ID documents.
Okay.
Again, does the photo ID really look like the person? And also to take a careful look at names. Obviously, there are some androgynous names out there, but if you have a female employee who's presenting work authorization documents that are clearly in a man's name, not to say that she couldn't have that name, but again, obvious red flags to look out for. Also, employees who, are not readily providing, seemingly basic personal information about themselves, i.e. their date of birth, their social security number, spelling of names, things of that nature.
It's a little bit of like, not just collect the data, but like put the thought and time into, while you're doing it, not just checklist items, like got it, but really a little bit of due diligence up front.
Yes.
Yeah, and the I-9 process, completion process, what it asks for is good faith compliance. And the employer, you're not required to be a document expert. You utilize the reasonable person standard. And if the new hires, presented documents that appear genuine and relate to the person who has presented them, and that's what Marissa is talking about.
Yeah.
And you discharge your function of completing section 2 of the I-9 and running that person through e-verify, and you receive a result back saying this person is authorized to work, I don't think the employer should be concerned. If there's an issue later in an audit or ICE raid situation, the ICE will let you know, and at that stage, of course, there'll be 10 days to do whatever correction, that is needed. But I think the message that we want to convey here is that if the employer does the correct thing and applies the right standards and exercises that good faith in I-9 completion and e-verify, if later on it turns out that there was an issue with the document and that it did not relate to the person and the employer had no way of knowing, then that's not something that's going to be held against the employer.
And that also makes sense with having those plans, right? Like if you have the processes in place and everything is in order and you have been doing everything by your plan and by the book, when this one thing or person situation gets through and they catch it at a later date, they're probably looking at it to say, all right, fix it, right? Rectify this. You have your 10 days and make it okay now, as opposed to like, man, everything's a mess and you really should have caught this, but you did. To just in that. My other question was, you had mentioned that, and I think this goes hand in hand maybe, that the staffing agencies are a bit of a red flag if in that sense, or what did you say, like targeted, that maybe if you're hiring most of your population through an agency, then that might be something of a red flag or a trigger for a further audit or evaluation?
It's actually a red flag on two fronts. In the first front, what we've always known, if staffing agencies, and particularly if you're talking about low-skilled workers like cleaners and people who work in plants or construction sites, there are certain industries, there are certain occupations that unfortunately tend to attract a large pool of the undocumented population. And so that's why, if you're dealing with, staffing agencies, just make sure that, they have proper I-9 protocols and employment eligibility rules, in procedures in place. And if it's an I-9 inspection, you don't have to worry because you are not the employer. Unless, there are facts and circumstances that create that co-employment relationship that I spoke about, or unless as the end client, you knew or you ought to have known that, the staffing agency was sending workers to you who were not work authorized. I think there's a famous case, back almost 20 years ago, in 2006, Walmart, that they found many thousands of, or workers who are working at Walmart stores, mostly cleaning staff, unauthorized to work. They found that certain Walmart managers knew about the unauthorized status of these workers. And there's also another company they investigated around the same time. They found that managers were involved in, helping some of the workers secure, social security numbers and the like. So that is one front that makes staffing agencies really a target. The other front is with regard to, staffing agencies who hire foreign nationals and sponsor them for work visas, primarily the H-1B visa. That's something that, the government has said, they're going to look at. The EOC chair said they're going to look at that. We are, handling investigations where, the Department of Justice is asking employers to provide additional information to explain and describe their visa sponsorship processes, to describe how do they handle, PALM labor certifications, that we were talking, about earlier? Are they favoring foreign workers at the detriment of US citizens and green card holders?
Wow. Okay. That is good. This is really very helpful. I know that those of us who are joining us and watching this and listening to this are going to get a lot out of it. And I know you guys are always reachable and approachable, so we appreciate that. We'll make sure that we share that information as well. And I just thank you again for taking the time to do this. It's been great.
Thank you. Our pleasure.
Thank you very much for having us.
Thank you for watching Inside Exchange, Topics for Manufacturers. We hope you found today's episode valuable. To learn more about the Council of Industry and explore additional resources, visit us at councilofindustry.org.